matter before the court today is, can you remind me, counsel?
The matter of Mr. Freddie Freestyler, Your Honour.
Yes. Counsel, can you introduce yourself to the court?
If it pleases the court, my name is Swan, S-W-A-N, initial B. Today I appear on behalf of the appellant in this matter, Mr. Freddie Freestyler, and I am senior and only counsel for the appellant, and I'll be speaking for approximately 15 to 20 minutes, Your Honour.
This is an ex parte
That is correct, Your Honour.
judgment. Can you just explain, refresh from my memory, for the benefit of our interlocutors, what that means?
Ex parte? Yes, certainly, Your Honour. So I might try and interweave the facts into this as well. So
I've just asked you directly, counsel.
Certainly.
Please answer the question.
An ex parte proceeding is where a decision has been made by a body or other organisation where legal rights may be affected, and Your Honour, in essence, all internal remedies have been exhausted, and it is a proceeding with where only one party appears before the court.
That was well defined. Where did you go to law school, Mr. Swan?
I went to law school at Southern Cross University.
An excellent choice. You were very well taught. Please proceed. Could you summarize pithily the facts?
Certainly, Your Honour. So the present appeal with Mr. Freddie Freestyler as the appellant was out in Sydney on a night out where he was tapped on the nose, or the face rather, by an individual. Mr. Freestyler has then taken a swing at the complainant, Mr. Bray Retired, and he missed. In any event, based on these actions by the appellant, Mr. Jerry Jackets, who is also a respondent in this proceeding, has terminated the appellant's Olympic agreement with the Australian Olympic Committee, and the appellant appeals to the Court of Arbitration for Sport now, having exhausted all internal remedies, where ultimately we will allege what we're submitting, that the decision was infected with bias, unreasonableness, and there was a number of other grounds, including that the decision was ultra-virus or beyond power.
Excuse me, counsel. Could you just advise me, was there any damage sustained by Mr. Ray Retired?
No, Your Honour.
No damage sustained?
No damage. Mr. Ray Retired, he slipped over, and the facts are not such to exhaustively conclude whether or not he had any psychological injuries giving rise to a cause of action, you can say, negligence, for example.
Were there any, but he did slip, were there any other symptoms? Did he cry out in pain, or were there,
No,
he didn't?
I do not believe so, Your Honour. Mr. Ray Retired, the doctor states that if Your Honour turns to paragraph 2 of the facts, the doctor seemed concerned but stated no broken bones, everyone all seems well.
Well, broken bones, yes, but there could be sprain, there could be hairline fracture, there could be any kind of bruising, and this could be an extremely susceptible person. And as we know from the law, as you know, in sports context, we take our victims as we find them.
Certainly, yeah.
So it's no excuse to say, I swung but missed, and caused a fall and potential damage here. And I actually have read that paragraph carefully now. He fell to the floor of the bar and cried out in pain.
That's correct, Your Honour. However, on the facts, a simple cry out may not amount to negligence. It may amount to negligence, Your Honour. However, that is not what this present appeal is concerned with.
Right. Yes. Then proceed with what this present appeal is concerned with. Thank you.
Certainly, Your Honour. So the first, would Your Honour like me to explain where jurisdiction is derived from?
I certainly would. Why am I hearing this?
Certainly, Your Honour. So the appellant alleges or submits that the Court of Arbitration for Sport, the CAS, has jurisdiction to hear the matter pursuant to clause 18.1 of the Australian Olympic Team Membership Agreement for Athletes, the agreement from here on, Your Honour. And clause 18.1 clearly states that if any dispute arises in relation to this agreement, that the CAS is the appropriate body or the appropriate appeals arbitration division to hear the dispute. And if Your Honour also turns his attention to clause 1.1.2 of my written submission, Your Honour will note that an appeal against the decision of a Rule 47, Your Honour, an appeal against the decision of a federation, association or sports-related body may be filed with CAS if the appellant has exhausted all legal remedies internally. And on these facts, Your Honour, the CAS is the final ground of appeal.
Have all legal alternatives remedies been exhausted then?
Yes, certainly, Your Honour.
So could you just reprise what those remedies are that have been sought?
Certainly, Your Honour. The facts are quite elusive in this. However, I understand that the AOC executive may have made a decision in this respect, and now the appellant, pursuant to the agreement and the procedural rules, the Court of Arbitration for Sport procedural rules, Your Honour, we now appeal to this court where the AOC prima facie has made a decision, a number of decisions, and outcome on my client.
Is your appeal by right, or is it? Do you have to show that something's gone wrong at the lower level?
Certainly, Your Honour.
So this isn't necessarily, you're not here just by right, you know.
No,
where are the irregularities then?
Certainly.
Because really, this is best handled, particularly decisions like this are best handled by the administrative body that have been set up, duly constituted, and that would seem to be the Olympic Committee and the President.
Certainly, Your Honour.
So I'm not interested in rehearing the merits of a decision. So where are the procedural irregularities here?
Certainly, Your Honour. If Your Honour turns to clause 1.1.3 of my written submission, you'll note that I refer to clause 18.4 of the agreement, which states that the sole grounds of appeal against the decision of the AOC executive, the CEO, or its, her, or their authorised delegate or delegates are that firstly, that was affected by actual bias, and secondly, was obviously or self-evidently so unreasonable or perverse that it can be said to be irrational. And Your Honour, on the present facts, Mr. Jerry Jackets, he has terminated the appellant's contract ultra-virusly, and on the facts, if Your Honour turns to paragraph 5 of the facts, you'll note that there is a perceived bias in the decision, whether that be actual or apprehended, Your Honour.
What would the bias be against?
Certainly, Your Honour. So on the facts, Your Honour, it says that Mr. Jerry Jackets has called the appellant, my client, a bit of a grub, a walking time bomb, if I'm not incorrect.
Well, he did actually, he does have an extremely short fuse.
Certainly, Your Honour.
And it's a time bomb that seems to go off with very little trigger.
Certainly, Your Honour.
So the analogy, in some respects, is accurate in that your client, just from a relatively harmless touching, albeit any form of touching is a battery, but in this case was, I think, de minimis, reacted by swinging at somebody. So this assault, this putative assault. So in what way is that by really calling someone out as assaultive, which is, I think, what he means by a grub and, a walking time bomb, someone who's violent, potentially violent.
Certainly, Your Honour. The appellant,
sounds accurate to me, counsel.
The appellant would contest what you just said. In respect of a bias, Your Honour, this was just one instance of a bias, and if Your Honour...
Alan can contest all he wants. I'm the judge here. Okay? Continue, counsel.
Certainly, Your Honour. So, if Your Honour also turns attention to that same paragraph, paragraph 5, you'll note that Jerry Jackets said on live television that he had always been a terrible influence on the young members of the team, and there were also half a dozen other situations. And furthermore, Mr. Jerry Jackets has also stated that he's threatening, intimidating, and he had always, not only has he said that he's a bit of a grub and a walking time bomb, but Your Honour, the appellant would contend that, or submit rather, that this would give rise to a reasonable apprehension of bias, and this is unacceptable for a decision.
Excuse me, counsel. Is there any truth to what Mr. Jackets has said? Have there been previous incidents?
As far as I'm aware, on the facts, Your Honour, there has not been.
Right.
From what so
he is the president of this organization, though.
Certainly.
And I think would be in a position that would have knowledge of his members, so industry expertise.
Possibly.
That the court has to take on board as well.
Possibly, Your Honour. But the principles surrounding natural justice are strict, and these arguably have not been adhered to.
Yeah.
And if Your Honour,
natural justice, know, it's been a while since my legal training. Counsel, could you just explain for me what those two words mean?
Certainly, Your Honour. So natural justice, there are two fundamental principles that surround natural justice. The first one is the hearing rule, where if a decision is made against a person, an aggrieved person, they must be accorded the right to be heard, the hearing rule. And the second of those is the bias rule, where a decision maker, they cannot discuss, they cannot make a decision, or they should abstain from making a decision if there is any reasonable apprehension of bias. And Your Honour, the seminal case in Australia dealing with with both concepts of natural justice is Kyer and West, heard in 1985, starting at page 159 of the Commonwealth Law Reports and ending at page 550. And before I proceed, Your Honour, may I dispense with full case citations?
Yes, you may, Counsel.
Certainly, Your
Thank
Honour.
you.
So Justice Mason, at paragraphs 28 to 34, clearly stated and if Your Honour turns his attention to 3.1.1 of my written submission, you'll note that I've referred to this case, where at paragraph 28 to 34, His Honour Justice Mason, it said, when an order is to be made which would deprive a person of some right or interest, or the legitimate expectation of a benefit, he is entitled to know the case sought to be made against him and be given an opportunity of replying to it. And Your Honour, in this respect, the facts are not particularly analogous. This concerned the cancellation of a visa in Kyer and West. However, the fundamental principle is that's come from the High Court of Australia, and that may act as a persuasive case in the present matter, Your Honour.
This is what we know as audio alterum partem, Counsel, hearing the other side.
Certainly, Your Honour.
Yes.
Certainly, Your Honour, the hearing rule. It's very well entrenched. And Your Honour will also note another key case that deals with this in the sporting context at paragraph clause 3.1.2 of my written submission. Refers to Rose and Boxing New South Wales Incorporated, which was heard in the New South Wales Supreme Court in 2007, where fundamentally the facts of this was that Mr. Rose was expelled from his boxing club, and he sought to appeal that decision. The rules of natural justice were not adhered to by the club.
How so?
How so? Certainly, Your Honour, where the club actually said to the appellant or the aggrieved party in that case that he was not allowed witnesses at his internal tribunal hearing, rather, and Mr. Rose, the appellant, he brought a group of witnesses along to the hearing, the internal hearing, anyways, and the internal body, the tribunal, if you would like to refer to it like that, they permitted him to have one witness. However, he was expelled from the club for 5 years. Mr. Rose took the Boxing New South Wales for judicial review and application to the New South Wales Supreme Court, where ultimately the decision was overturned as it was infected by it was not the requirements of natural justice. The strict requirements of natural justice were not adhered to, and ultimately we would seek to the appellant would rely upon a principle like that in this case, where Mr. Jerry Jackets has not allowed.
Were there witnesses that, to what? A witness to what? How would this prove anything other than your client did precisely what he did,
Witnesses in which respect, Your Honour?
So I thought you were arguing on the analogy to the Rose and Boxing case.
Certainly.
And the problem there was not so much that the other side wasn't heard, but their panoply of witnesses weren't brought in, though they were allowed one.
Your Honour, the issue in the Rose case was that the requirements of natural justice, they were not adhered to because not only the one witness that was permitted in may not, Your Honour, I haven't read the case in detail, however I know the facts on a brief scale, and there was a rather complete dispensement with procedural fairness in that the appellant, he sought to have a number of witnesses at the hearing, and there was very limited process there, and my understanding is also that this was infected with bias.
Counsel, you've also raised another term here. You've introduced another term. We've been talking about bias. We've also been talking about hearing the other side. Now you've mentioned this word fairness. Is that something that I should be talking about in a court of law? Is fairness actually a principle?
Certainly, Your Honour.
Yeah.
Although my written submission does not raise this at all, the principles of equity, they may be strict insofar as a court is concerned, where fairness needs to be the underwriting. It needs to be an underwriting consideration of the court in any aspect.
Absolutely. Do you think your client has been treated fairly?
Certainly not, Your Honour.
How so?
Certainly not. Ultimately,
Where's the key breach of natural justice, putting aside the bias issue?
Certainly, Your Honour. So the President, if Your Honour turns his attention to paragraph 3 of the paragraphs 3 and 4 of the facts, you'll note that the appellant even asked the President, Mr. Jerry Jackets, to be heard, and Mr. Jerry Jackets said there isn't anything to discuss. The decision is final. You aren't going to be on that plane to Rio, and there is nothing you can do about that. And Mr. Jerry Jackets ultimately, in saying that, did not comply with those rules of procedural fairness. And Your Honour, we would ultimately contend that decision to terminate that contract was ultra vires, so it was beyond power. The constitution of the AOC, the agreement, and the CAS procedural rules, they clearly, the agreement stipulates that it must be the AOC executive that terminates the agreement. If there is a termination, and this did not occur, it was the President who terminated the agreement beyond power. And Your Honour, in terms of a fairness-related argument, one case that the appellant would rely upon is the matter of Nick Darcy, Your Honour, and that was heard in the CAS, and the respondent in that respect was the Australian Olympic Committee, where the facts are very analogous, where the tribunal ultimately, or the court, they ultimately overturned the decision of the President. The President terminated Mr. Darcy's contract after a night out in Sydney, where Mr. Darcy caused extensive damage to an individual through an elbow to the face. This individual was extensively injured, and ultimately the issue in this respect was that the requirement to the decision had to be made by the Australian Olympic Committee executive, and it was not made by that body. It was made by the President solely, and the Court of Arbitration for Sport, they overturned that decision, Your Honour. And I would invite the current tribunal to do the same in respect of Mr. Freddie Freestyler today.
Yeah. Do you have any summary remarks to make, Counsel?
Certainly, Your Honour. Ultimately, the written submission outlines issues like unreasonableness and defamation as well, Your Honour. And in any event, Your Honour, the appellant contends that natural justice was not complied with, unreasonableness, and the decision, if it wasn't infected with actual bias, was certainly apprehended bias. And ultimately, Your Honour, we would contend that we would invite this tribunal to overturn the decision that Mr. Jerry Jackets has made, and